Welcome to our Rapid Fire Wednesday Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner with WR Immigration in San Diego, and I'm here today with Miki Matrician, the co-managing partner of our Boston office. And yes, I'm still in Boston, so good to see you, Miki. For today's installment of Rapid Fire Wednesday, we're going to go back to our series on mergers and acquisitions. We took a little bit of a detour to talk about takeaways if there's a Trump 2.0 administration, and then also what if there's a Harris administration. And then we did a discussion on Parole in Place, which is the family unity program that just came about. So we're super excited about those topics, and we wanted to get to those while they were in the moment. So now we're going to head back to our mergers and acquisitions series. Last time we discussed the issues with H-1B, H-1B1, and E-3s. Today we're going to talk about the impact of mergers and acquisitions on the L-1 classification, the E-1, and the E-2 classifications.
Yeah, we started our series on this M&A topic because M&A activity is picking up a little bit this year compared with last year where it was a little bit slower. And I think it's an important topic because, when companies are going through due diligence for mergers and acquisitions, there's so many pieces that they're dealing with, and often immigration is the forgotten piece. And it could mean that a foreign national employee has, negative impacts as a result of the merger or acquisition. And it's really important that global mobility and human resources and Immigration Counsel are looped in and able to help with the analysis before the deal happens.
So when HR and global mobility professionals hear about a merger and acquisition, of course, for us as Immigration Counsel, we're like, well, you should think of immigration first. But I know, as Miki said, that isn't always on the table. There's so many other pieces to it. But having a checklist and say, oh, let's contact our Immigration Counsel. Contacting Immigration Counsel is the first step in order to make sure that employees are protected, right? Because there's major impacts on what can happen in a merger or acquisition, depending on what stage it's at, what the whole process is. And that could result in the loss of some potentially really qualified employees. So that's one of the things that we emphasize. Talk to counsel first. Get your list of foreign national employees together, what their status is, their expiration dates, if they're in the green card process in any capacity, and then kind of go from there.
Yeah, exactly. And Kimberley, can you just briefly remind us about what HR professionals need to know in terms of I-9s in a mergers and acquisitions context?
Yeah, sure. So for I-9s, in I-9 compliance, we want to think about, is the company hiring the individuals as new employees, in which case new I-9s will be completed. And keep in mind, there's still the 3-day rule of completing those I-9s. If the new employer is going to essentially keep the employees on, not change of employer, but assume all of the rights and obligations and responsibilities that are affiliated with the I-9 forms that have been completed, then they can proceed without completing new Forms I-9. They do need to be aware of the risk that they could be inheriting a lot of mistakes on those Forms I-9. So it's something to really think about that goes into the process of that deal. That's one of the other considerations to think about when it comes to I-9s, because it could have a hefty financial impact on the company.
Yeah. All right. So let's delve into the impact on L1s. For the L1 visa status, really the basis for the L1 is the corporate relationship between the U.S. entity and the entity abroad where the foreign national worked, right? So if the corporate structure changes this, that's something that could put the L1 visa holder status and work authorization at risk. Let's take the profile of a company that has an L1 blanket. So as a reminder, the L1 blanket is basically a pre-approved petition with the USCIS that has the government essentially pre-approve the corporate relationship between the U.S. entity and the entities abroad. So if that facilitates the foreign national employee's application so that it's quicker than having to go through the default of getting a petition approved with USCIS for that specific individual. So for companies that have an L1 blanket, if an employee moves from one entity to another within the corporate blanket approved organizational structure, there is no amended filing required. So you can move from one entity to another seamlessly, so long as the company's new employing entity and the old entity are still on the blanket. If it is an individual petition situation, then the corporate structure may necessitate an amended filing with USCIS. One thing to watch out for is the spin-off situation where the company abroad, for example, is spun off and, sold off to another company. Then that might break the relationship between the U.S. entity and the former employing entity abroad. And so that might be a situation in which the L-1 employee is no longer eligible for that status.
Okay. So those are good points. One of the things that we were talking about before is what is the situation if the L-1 individual employee's office abroad, where they had been working prior to being transferred to the U.S., is going to be closing its operations, while the U.S. entity where the employee is currently working will remain open. What kind of impact does that have?
Yeah, so basically, the company has to be international, meaning that there has to be at least one entity abroad in addition to the one in the United States. And so long as that's maintained, the fact that the employing entity abroad is closed does not mean that the L-1 employee is disqualified from continuing on in that status.
Okay. Well, those are good points to think about because a lot of times, the closure of the overseas office doesn't really come to light or it's not really thought about. The other thing that we also want to look at is that individual continuing to hold an L-1 managerial or executive level position. So if the change in the organization means a change in that individual's job structure, meaning their duties and responsibilities, and they are no longer going to be in a manager or executive level capacity, that could result in an amended L as long as they're qualified under specialized knowledge. So those are some things to consider. The other thing is that, we just want to make sure that the analysis is being done not just at the corporate level, but at the employee level, right? Looking specifically at their duties and not just their job titles. So I think we talked about L1s. Those are most of the points that people should understand and think about. But what about the E-1 and the E-2 for those treaty traders and treaty investors? Is there a different type of analysis in that situation?
Yeah, definitely. So it's an entirely different analysis when it comes to E-1s and E-2s. And the E-1 treaty trader and the E-2 treaty investor are essentially based on bilateral treaties between the United States and another country. And these treaties are essentially for the purpose of furthering the U.S.'s ties or relationships with these countries. And there's about 60 countries all over the world in EMEA, Latin America, and APAC that U.S. has these treaties with. And it's essentially the nationality of both the individual and the company that matters for the E-1 and E-2. And so, it might make sense easily to everybody about the nationality for the employee, but what about the company? What does it mean to be of a particular nationality for a company? So it really goes to the owners of the company and what their nationality is. For publicly traded companies, it's really the country where their stocks are traded primarily or exclusively. And so, for example, if the company's stocks are traded in the Tokyo Stock Exchange, then that company is essentially Japanese in nationality and their employees' nationality has to match.
Okay. So what if during the acquisition, the ownership now transfers over to the United Kingdom, right? So now there's a publicly traded company that's on the London Stock Exchange. How does that impact the individual who is a Japanese national?
Yeah, that's an excellent question. And that's exactly the kind of situation that could be impacted, right? So in that scenario, that Japanese national would no longer be eligible for the E-1 or E-2.
I mean, that creates a really tough situation.
Yeah.
Right. Those are some things that we think about.
Exactly. And hopefully if that E-1 or E-2 doesn't work out anymore, maybe they're eligible for an L-1 visa. But those are, that's an additional analysis that we already talked about.
Yeah, that's a tough situation if the merger and acquisition deal ends up in the disqualifying of an employee. So now they're no longer in non-immigrant status, potentially in the United States. So it's definitely something that could potentially be avoided if we have that discussion about the immigration situation of individuals prior to the deal close.
Absolutely. And, like we talked about, there's so many legal and financial pieces to these deals that it's easy for in-house counsel to forget about the immigration piece. But, that's something that HR and global mobility can kind of remind, company executives about, so that they are kind of remembering to think about the immigration piece and that they can be looped in ahead of time, which then will trigger immigration counsel to be notified as well and jump in and help with the analysis. And, if companies have immigration counsel that's experienced in mergers and acquisitions, then there should be like a streamlined process where, the deal information and analysis is limited to a small group of team members at the law firm, so that the information related to the deal, which is highly sensitive and confidential, can be kept under wraps. And so if one of the issues is that in-house counsel feels like, well, and is this information that we should be sharing with, additional group members or team members, global mobility and human resources professionals can remind in-house counsel or let them know that, the immigration counsel is used to handling these types of deals and they know how to treat the sensitive information so that it is contained.
Right.
That might be helpful.
Yeah, it's really good information. Something to think about. And that's a wrap for today's episode on mergers and acquisitions, the impact on L1, E1, and E2 classifications. And our third part in the series is going to be mergers and acquisitions and the impact on the permanent resident process. So if you don't already follow WR Immigration, follow WR on LinkedIn. Also follow Miki and I on our individual profiles. And we turn this episode into a newsletter every week so that you can get the summary about it and you can also subscribe. So we would love to have you subscribe. And thanks again, Miki.
Thanks. Good to see you.